For today's virtual talk, I am delighted to present and have with us Cynthia Khoo. Cynthia is a technology and human rights lawyer, a research fellow at the Citizen Lab. She also serves on the board of directors of Open Privacy. And I'm delighted to have her with us today because she's an alumni of our LLM program, LLM Law and Technology program from the University of Ottawa. Where she interned as a research student and junior counsel at the Samuelson Glushko Canadian Internet Policy and Public Interest Clinic, usually known as CIPIC. Cynthia is the founder of Technos Law, a sole practice law firm, and she has represented clients in interventions before the CRTC and the Supreme Court of Canada. Without further ado, I will give the floor to Cynthia for about 30 minutes, and I will then moderate a Q&A session with the audience. Cynthia, the floor is yours. Thank you.
Thank you. Can you hear me?
Yes, we can.
Thank you so much, Florian. Hi, everyone. Thank you so much for attending my talk today. I know there's a lot going on right now and people aren't working with a lot of spare bandwidth, so I truly appreciate it and will do my best to make this worth your while. A reminder that this talk will be recorded and posted afterwards. If you missed Susie Dunn's talk last week, it was fantastic. Would highly recommend you go watch that on the YouTube channel. And with apologies to Oscar Wilde, what is the importance or unimportance of being unintended? So when it comes to digital platforms, by now it's almost cliche to roll out the list of system-level disasters that these companies have facilitated. Social media has given rise to systemic online abuse, disinformation, voter manipulation, and balkanized public discourse. Gig economy platforms like Airbnb and Uber have impaired rental markets for low-income tenants and undermined the public transit system. Google Search has repeatedly provided racist and sexist search results. For example, at one point, if you were to Google 3 Black teenagers or 3 white teenagers, you would get the types of results shown on this slide. Lastly, researchers have shown that YouTube's recommendation engine systematically drives viewers to increasingly extremist right-wing videos, drawing them ever deeper into a network of linked white supremacist and misogynistic accounts, arguably furthering hate-based violence and abuse in the physical world. So what do all of these phenomena have in common? That's right, they've all been labeled unintended consequences. This matters because for digital platform companies, that label conveys a message. It's, well, we didn't mean to do it, or we didn't know that would happen, so it's not really our fault. That lack of intent or lack of knowledge undermines the idea that platform companies should be held legally responsible for the harms that result from their businesses. Is that right, though? Given the scale and severity of some of these harms, and given their disproportionate impact on historically and ongoingly marginalized communities, it seemed worth pulling this notion apart a bit. So I set out to do 3 things, which will form the rest of this talk. First, I took the idea of unintended consequence at face value. How could it be that in a complex system such as a platform network and its users, no one anywhere did anything wrong or illegal, everything worked as it was supposed to, and yet you still ended up with widespread harm that was more than the sum of the platform's parts? This is where I'll introduce the idea of emergent systemic harm. Second, I'll show that just because the harm was unintended doesn't mean it wasn't foreseen or even completely predictable. It just depends on who was doing the foreseeing and predicting. Third, I connect up these ideas to the legal test for reasonable foreseeability of harm in establishing negligence under Canadian tort law. To be clear, I'm not necessarily advocating that online platforms should be held liable for negligence wherever or whenever they facilitate harmful consequences. What I do is offer some arguments for why that might be a good solution in some limited circumstances in the context of marginalized groups, and how I think we should go about doing it, at least as far as the foreseeability test is concerned. Lastly, I may have been a bit ambitious with my slides today, so if you want to know more about a particular concept or if I skip over something, feel free to ask during the Q&A or email me afterward. So what is emergent systemic harm? It's a term I came up with to capture the specific kind of platform-related harm I was interested in naming, researching, and potentially applying the law to. First and foremost, the harm we're looking at is collective and structural. So I wasn't interested in the harm of one individual being abused or one user's privacy being violated. There's already a ton of expertise and scholarship out there looking at these harms as experienced by individuals. Legal remedies also exist, such as the offense of criminal harassment or the tort of invasion of privacy, and they work to varying degrees of success, but they are there. The harm I'm looking at goes beyond each individual's case and cannot be confined to a private legal dispute between a digital platform and a single user. It's the type of harm that comes through in patterns and institutional design. For instance, it's the systemic pattern of Black people on social media being targeted for racist abuse, or the systemic pattern of women receiving rape threats and death threats whenever they speak online on public affairs. So it's not about the choice any one user makes, but about how the platform designed the user environment so as to constrain and nudge all of their users' choices towards specific objectives, sometimes known only to the platform and often not in the user's best interest. Systemic harm is recognized as legally actionable in Canadian human rights law, such as equality and non-discrimination codes, and environmental law. Interestingly, there's a lot of metaphors drawn between the environment and the internet ecosystem, and environmental law recognizes that it's not just about the harm to one fish or to one tree, but the overall damage to the ecosystem and its ecological networks. So basically, my focus is on the digital platform version of ecological harm to marginalized communities. As for emergence, this occurs when a complex system unexpectedly produces a result that was more than the sum of its parts. For example, as some of you might recognize from the scene, when the robots in Westworld spontaneously evolved beyond their programming and started acting autonomously outside of their coded scripts. Sorry for the spoiler if you haven't seen it yet, but I'm pretty sure there's a limitation period on that. I took this term from the robotics and artificial intelligence field, where stories abound of AI unexpectedly doing something it wasn't instructed to do, or conversely, doing something it was instructed to do, but in a completely unexpected, one might say unintended way. So putting these two pieces together, emergent systemic harm is when system-level harms emerge unexpectedly from a complex system. The system's constituent components, each in isolation, didn't necessarily raise legal or ethical concerns, but they still somehow worked together or interacted in a way that produced harmful consequences on a collective and systemic level. This term is quite broad and versatile, and it can be used across numerous contexts, so long as the harm is characterized by being both emergent and systemic. In this case, I'm focusing specifically on emergent systemic harms facilitated by online platforms, and within that, only systemic harms to historically oppressed and ongoingly marginalized communities. So I'm not looking at, for example, competition harms or democratic harms, which are also systemic harms, but just not the focus of what I'm looking at here. So how does emergent systemic harm, i.e. an unintended consequence, happen? Obviously, I can't speak for all of them, but I looked into some of the higher profile ones associated with online platforms and marginalized communities, such as the examples I showed at the beginning of this talk. This is a non-exhaustive list, so there may be other elements, but I found 6 common factors that can contribute to the kind of unintended consequences we've seen from online platforms. The key thing to remember here is that for each of these elements, the platform didn't necessarily do anything wrong, illegal, unethical, or even unreasonable in setting up that particular component, or it was a more neutral standalone component, such as time, but it was only in the interactions between all the components together that they gave rise to a harmful result. So quickly going through each of these. An algorithm is an automated computational set of instructions that can be optimized to achieve a particular result. For example, YouTube's recommendation algorithms were set to promote videos that would make viewers spend as much time on the site as possible. Totally legitimate goal. But combined with human nature, in practice, that became instructions to promote as much sensationalistic, disinformation-filled, conspiracy-fueled, racist, and misogynistic content as possible. Second, how the platform is designed, or its technological affordances, dictates what users are able or subtly persuaded to do or not do on the platform. For example, Zainab Tufekci points out that when Facebook only allowed users to like a post rather than express any negative emotions, this systematically slanted the tone of the whole site towards more positive content. Lesser engagement and thus lesser algorithmic boosting and visibility went towards more quote-unquote negative content, such as Black Lives Matter protests, posts exposing abusive behavior, or content by activists and human rights defenders. In isolation, the like button seems like a trivial design feature. As part of a broader system where monopolistic platforms govern public discourse, it becomes a political one. Third, most digital platforms have set themselves up to make money off of our personal data and our attention through the ad-driven model. Again, there's nothing inherently wrong about using an ad-driven business model, but when your profits rely on personal data and attention span, and you end up pursuing commercial growth at all costs, then combined with some of the other components here, that's when you end up doing things like accidentally breaking democratic institutions. Time and scale are fairly straightforward. Emergent systemic harms don't all happen overnight. Sometimes this is because they only emerge once the platform has reached a certain size or a certain number of users. For instance, if Facebook had 100,000 users as opposed to over 1 billion, it wouldn't have the same level of influence that it does, and therefore wouldn't be as much of a concern. Or the harm might not emerge in the first place if it's one that requires scale and reach to happen. Finally, there are the users themselves. Tarleton Gillespie has described how most people use online platforms instrumentally. They're on there for their own day-to-day interests and goals, to talk to their friends, to share articles. They're not looking at the bigger picture of platforms and society, and that completely makes sense. It's not unreasonable to accidentally share misinformation, and it's not illegal to lack digital literacy or usually share questionable or offensive content. But when you multiply that by millions of people expressing hate through online abuse, or millions of people sharing the same pieces of misinformation, then that's when individual behaviors that are each beyond the reach of the law come together to collectively result in far-reaching systemic harms that intuitively we feel the law should be able to address. Mike Masnick, a platform regulation expert who writes the TechDirt blog, has said, "You can't blame Facebook for human nature." And I completely agree with that. However, I do think you can blame Facebook for knowingly exploiting human nature in pursuit of commercial gain, regardless of the consequences. So back to our initial question, how do unintended consequences happen? This is how they happen: through unexpected interactions between system components that on their own are completely above board and may not immediately indicate foreseeable harms, but together create a perfect storm resulting in harmful system-level consequences. So based on this, I would invite regulators, developers, users, and other stakeholders to watch out for these elements and maybe identify additional ones going forward, where platforms with all of these components should put us on notice to more proactively monitor and analyze their potential to result in systemic harms, and then take preemptive measures where possible. Okay, so we've gone over how an unintended consequence might spontaneously emerge from a platform that didn't technically do anything wrong. But is an unintended consequence always an unforeseen one? Short answer, no. As I was writing my paper, I realized it was harder and harder to keep a grasp on exactly what was an emergent systemic harm. And I realized that was because I'd started with the platform's own claims of unintended consequences. The logic was, if it was unintended, then it must have been emergent. But thanks to leaks and employee whistleblowers, we now know that some of these harms weren't emergent at all. They weren't unexpected or unanticipated. The platforms knew well about some of these consequences ahead of time. They may not have intended them, but they certainly didn't do anything to stop them from happening. For example, with these headlines, YouTube ignored warnings letting toxic videos run rampant. Facebook downplayed early Cambridge Analytica concerns. Uber knowingly rented flammable cars to drivers in Singapore. Facebook executives shelved internal research showing how it might make its platform less polarizing. And so just because a consequence was unintended doesn't mean it wasn't still known and simply accepted as an unfortunate side effect that externalized collateral damage onto users, while the platform itself reaps the profits of continued engagement. So here we have harms that weren't actually emergent after all. But what about if a platform really didn't foresee harm? Does an unintended and unforeseen consequence mean it was unforeseeable by anyone? Again, no. The short history of platform-facilitated harms is replete with what communications lawyer Harold Felt has called Cassandra Freud, a portmanteau of Cassandra of Troy, who was cursed to forever make true predictions that were never believed, and Schadenfreude, taking pleasure in someone else's misfortune. Climate scientist Katherine Hayhoe describes it as the bitter pleasure of things going wrong in exactly the way you predicted, but no one believed you when it could have made a difference. As seen here, Zeynep Tufekci predicted Facebook's role in the Myanmar genocide back in 2013. Ian Kerr was writing about applying fiduciary duty to information service providers as early as 2000. Black feminists and trans women have the unfortunate honor of being on the cutting edge of technology-facilitated abuse, as they are some of the first to receive it, and in spades. So you can see here with some of these tweets on the left, Sloth Mom, hashtag Black Lives Matter, I don't say listen to trans women because we've got some magical sixth sense. We can't see the future. We know because we are usually the first they target. Or right below that, Caitlin Greenedge. A good rule of thumb in political analysis is that if someone claims no one could have predicted X, I guarantee you a Black feminist scholar wrote a whole ass paper outlining the possibility like 10 years before it happened. And for the love of whoever, whatever you hold dear, if there are any developers out there, please never ever add a location tracking, location disclosing, location pinpointing feature to your product without first consulting experts in intimate partner violence and gender-based abuse. So once I started thinking about these particular cases, again, the idea of emergent systemic harm seemed to stabilize. What was emergent or unexpected about any of this? And I realized it's because these consequences were only allegedly unforeseeable to the homogenous and privileged executives running the major platform companies. To human rights and sociology experts, academics, and vulnerable and marginalized groups, these harms were not just foreseeable, but downright predictable. In other words, emergence is in the eye of the beholder, which is how we get to the platform foreseeability gap. This is my term for the discrepancy between what those who own and manage platform companies are ostensibly able to foresee and what many employees, vulnerable and marginalized users, oppressed communities, outside experts, academics, and human rights advocates can and do foresee. So one goal of platform regulation, I think, should be to close this gap by increasing the ability of platform companies and the technology sector generally to foresee harm from their products and services to vulnerable and marginalized communities and then act accordingly. Now, turning to the law, can you hold a platform liable for an unintended consequence? I looked at one potential path to platform liability specifically just for emergent systemic harm to a historically marginalized community. This would be through negligence in tort law, which provides that you can hold someone liable for an unintended consequence under certain conditions. This route could supplement human rights legislation, which also states that intent is not required to establish a legal claim of discrimination. The advantage of tort law is that it would provide a backstop to regulation, enable class actions to distribute costs for users, and allow impacted non-users to sue, which is important given the systemic nature of the harm reaching beyond platforms themselves. Finally, because we're looking at systemic harm arising from the platform overall and focusing on elements the platform has direct control over, i.e. its algorithms, affordances, and business model, this legal path is less likely to run into intermediary liability barriers. It doesn't hold a platform responsible for any specific piece of content or treat them as a speaker or publisher of any one user's post. Rather, the liability would be for negligently cultivating an environment and creating and fostering conditions and system interactions that gave rise to systemic harm to a particular marginalized community on the basis of having introduced those risks to vulnerable users for its own commercial gain. I should also note that I focused exclusively on the foreseeability element of the test due to project scope and constraints. This means I haven't looked at other steps of the test, which might bar this proposal, such as proximity, duty of care, standard of care, causation, or remoteness. That's what all future papers are for. But this analysis is intended to contribute to the extent that foreseeability does play a role in meeting the legal test and to put to bed that specific idea of unintended consequence in the context of digital platforms. Under the test for negligence, a defendant is liable if the harm was a reasonably foreseeable consequence of the defendant's conduct, provided, again, they meet the other criteria. To determine whether or not something was reasonably foreseeable, courts must consider what would have been foreseeable to a reasonable person, which is a well-established legal concept that actually used to be the reasonable man. So yay, progress. So who is the reasonable person? This is where the platform foreseeability gap comes into play. We've seen that some systemic harms can either be unforeseeable or completely predictable, depending on your vantage point. But where marginalized groups are concerned, they are suffering from harms that they did foresee because those who design and control our digital environments either also foresaw those harms but didn't act or couldn't foresee and wouldn't listen. I argue that to ensure that at least this part of negligence law is able to effectively capture platform-facilitated systemic harms to marginalized communities, we must recalibrate what is considered reasonably foreseeable harm based on a more comprehensive and contemporary understanding of the reasonable person. So who is the reasonable person today? The reasonable person is intersectional. According to the Supreme Court of Canada, the reasonable person must be taken to be aware of the history of discrimination faced by disadvantaged groups in Canadian society, protected by the Charter's equality provisions, and is supportive of the principles of equality. This means that the reasonable person should understand power dynamics, understand how marginalized groups are differently and disproportionately impacted by seemingly neutral rules. For instance, platform algorithms are essentially sets of computational rules that govern our online experiences. The reasonable person is also vulnerable, or at least understands what it means to be vulnerable to the world and to both the bad and well-intentioned actors in it. I was especially struck by this passage from Hadley Friedland about the Cree reasonable person. I can identify nothing about our Cree reasonable person that would protect her from suffering the fate of far too many Indigenous women and girls across Canada. Nothing. The reasonable person should understand the realities of living in a deeply and violently unequal society. Finally, the reasonable person is relational. I base this idea on Craig's theory of relational copyright and Ian Kerr's work on relational privacy. The core concept, rooted in feminist critical theory, is that people and our legal rights and interests are all interrelated and connected webs of relationships and power dynamics, which are in turn structured and shaped by each other and how we are able to exercise those rights and interests. Building on those ideas, I propose the concept of relational foreseeability. As applied to digital platforms, this means dispensing with the startup founder myth and recognizing technology CEOs and engineers as not lone genius nerds or boy kings above it all, but as legal actors just as enmeshed in the socio-political and cultural trenches as their users, while being equally shaped by those networks of relationships, power dynamics, and social and cultural norms. This places on them a responsibility to be able to foresee what their users might foresee, whether that's how a location tracking app can be used to stop victim survivors of intimate partner violence, or how hate groups learn to amplify abuse by gaming content moderation features. What this amounts to, and I suppose this is essentially my grand conclusion, is that the test for reasonable foreseeability in negligence law must incorporate intersectional and relational accounts of foreseeability. What is reasonably foreseeable harm must be harm that was foreseeable to a reasonable person who understands systemic discrimination through an intersectional lens, who believes in the right to equality, who knows what it means to inhabit vulnerability, and is a legal actor enmeshed within and not transcended above the relevant relational, social, cultural, and political systems and networks. Otherwise, the law will continue systematically excluding justice from the most marginalized and vulnerable users among us, whose injuries are disproportionately more likely, more frequent, and more severe, and yet routinely unforeseen by those introducing the risks of those harms, while also holding the power to prevent or mitigate them. So on this basis, it doesn't matter at all whether or not a harmful consequence was unintended, unless and until all the headlines start saying, and are accurate when saying, it was a totally unforeseeable consequence by anyone. We have work to do. Thank you.
Thank you, Cynthia. You were able to fit all your content in a few minutes. Good job. So we already have like some questions in the chat. So I'm gonna start to like ask you those ones. For everybody, so like please ask all your questions in the chat. I have added like a small picture because last week some of you were confused on how to open the conversation tab. So you just need to click on the chat bubble. So one of the first question that was asked, and I think you may have, after that person asked the question, like kind of answered it, but still, the question is, when you speak about unintended, unexpected results, do you mean from the point of view of the platform administrators, or contextually for the users, like Hélène Nissenbaum, for example?
That's a great question, and that's exactly how what I ended up struggling with in my paper, because when I first started, the idea was unintended consequences and unexpected was the same across the board, because these consequences were all being labeled unintended and unexpected. But once you start digging into them, you realize that wasn't the case. There were almost two standards of unexpected, I guess. There was what the platform expected to happen, which seemed at some points to almost be a naive, overly giving of benefit of the doubt that there are no bad actors out there who would abuse their technology, and people who have been the victims of technology facilitated violence who will look at a certain product or service and see right away. And for some reason, those people aren't being consulted, or their views aren't being incorporated into how at the development and design stage of the technology. And so when I started off, it was, how did this happen? How was it unintended? But whoever asked that question is right. It should be, right now, I think it's being approached publicly and loudly from the perspective of the platforms. And what I'm saying is that for the purposes of law or just general accountability and ethics, we should shift it so it's more formally from the and consistently from the perspective of the users and the most marginalized who are most impacted and harmed.
Okay, thank you. Another question, more like technical by a lawyer for a lawyer. So the next question is, so this is, well, the attendee is asking if it's a negligence-based theory and not one based on international tort or form of strict liability. And the person mentioned Rylance versus Fletcher as a reference.
Yeah, so it would be negligence-based, and the reason that I jumped to negligence-based was specifically because the starting point was unintended consequence, that's what it lent itself to. But there are different ways of going at it. So with respect to strict liability and intentional tort, I don't think, because I am still aware of, and I still hold very close to heart, intermediary liability principles, and so there's still that balance of how to hold platforms accountable for harms that result from their business activities and how to reduce harm for marginalized groups while also not quashing all of the benefits of legal shields for online platforms. And something like, I think intentional liability may be, there's two things there. One, it may be too high a standard because so much of it is unintentional. And the other thing is, because I'm looking specifically at the context of systemically oppressed groups, there's a case called Bauderia, which actually, where the Supreme Court of Canada ruled against an intentional tort of discrimination, for example, although the case has been narrowed since. So something interesting, though, that would be worth exploring further is that Raka Ruparilia has written a paper proposing something called the tort of negligent discrimination, which might be worth exploring. With respect to strict liability, I think that's, I guess, if intentional is too high a standard, strict liability may be too low a standard. Because the thing that about the negligence standard that I like is that you have the defense of standard of care. And so the idea is not necessarily to hold them liable for harms. The idea is to encourage digital platforms in the tech sector to put into place practices and policies that will prevent and mitigate those harms in the first place. So if there's a way where they can dispense with liability by showing that they've done their due diligence, for instance, whether that's ensuring diversity on staff, ensuring consultation with marginalized groups and impacted users, then that's a possibility. Where strict liability is relevant is, I didn't have a chance to talk about in the presentation itself, but you'll notice that I talked about whether something is unforeseeable, and then all of the examples I gave were more pseudo-emergent harms, where if you looked in, they actually were foreseen or foreseeable. But there's actually a further question that needs to be asked, which is, what about with the advance of machine learning algorithms, unsupervised algorithms? You have a harm that is truly, truly, genuinely unforeseeable by anyone. So at the end of my paper, I look into that. And at that point, I do find a place for strict liability where someone deploys an unsupervised machine learning algorithm in an extremely high stakes context. Then at that point, I think harm should be addressed on a strict liability basis.
Okay, thank you. So we have two other questions of people like trying to better understand how your proposal interface or like interact with, other non-concept or framework. And one of the first one, and you kind of mentioned this at some point in your talk. So someone is wondering how your proposal interact with internet liability frameworks, and maybe because of what's going on south of the border. Maybe like personally, I would love to maybe hear you about all the current conversation around Section 230 in the US, and maybe like your opinion about the Canadian framework, which is like, how to say that nicely, like a puzzle. of different pieces between the provinces and even at the federal level. So yeah, if you could like explain to us how you see that like interact or interface.
Okay, so I heard three questions in that. The first one was how my presentation interacts with intermediary liability law. The second was maybe a brief minimal comment on the Section 230 stuff happening in the States. And the third was, I think, the current framework of intermediary liability law in Canada.
Yeah, so
Okay.
how it interact with all that.
The first about how this interacts with intermediary liability law. So this was actually a really interesting project for me because when I first went into it, it was on the basis of my thought was I'm going to do an intermediary liability platform regulation project. And I ended up completely not at all. Like this is basically first year tort law as applied to digital platforms. But it's because I realized so much work has already been done on platform regulation that this is kind of where the newer work was to be done, where there is still, so for instance, Harold Feld's book, ebook on platform regulation, he mentioned that there is still space left open for private right of action. And I thought, well, okay, if someone were to go that route, what would it look like? What would the substance and contents of that law be or should be? And in this case, this is the reason, also the reason why I focus on systemic harm and not individual harms, because I don't think that what I'm proposing would be available as a legal remedy to a single person who was being harassed online by a single person, for instance, because in that case, you'd be holding the platform responsible for the content posted by whoever was doing the abusing. But for me, it's not if one person gets harassed or one person is violated. It's if you can show that say 500,000 people have been violated and they all belong to the exact same marginalized demographic group. And the platform has been set up in a way to subtly encourage or foster the conditions that result in that harm. That's the point at which I think something like this might come in that might be useful. And again, I feel like I should emphasize this in some senses, what one was more of a thought experiment, and two is a very tiny piece of the total puzzle. Even looking at the negligence test alone, it's a multi-step test. Foreseeability is just one of the elements. I haven't looked at, for example, causation or proximity or remoteness. I could think of how to make arguments for them, but it's possible that these actions will fail if you put forward arguments on any one of those. So like that's something that we have to do further research and analysis into. Second, on the point of the United States, so to be honest, I haven't spent too much time looking into that just because in terms of the executive order, I think it's pretty clear by this point, it's fairly nonsensical in terms of its contents, in terms of how it tasks, what it tasks the FCC to do without jurisdiction to do so. The fact that it's not binding because it actually, they don't have the jurisdiction to tell the FCC to do something. So they only instructed another government body to request that the FCC do this thing, which it technically does have the power to refuse. And that's ignoring how many decades of prior jurisprudence and regulatory history of the FCC not regulating websites. As for your third question, the current landscape of intermediate liability in Canada, you said that was a puzzle piece, and I actually think that's to our advantage. I think that it's a good thing that Canada has taken a piecemeal basis to intermediary liability because, and I actually have an op-ed coming out in a few weeks about this, I don't think it's one size fits all. I think it's actually almost ridiculous that you would have one across the board rule where the platform is liable for everything or liable for nothing, regardless of whether it's copyright, whether it's non-consensual distribution of intimate images, whether it's online abuse. These are all different things with their own pre-existing areas of law, pre-existing lines of jurisprudence and policy objectives. And it doesn't make sense. Like, I think platform liability should be addressed contextually, informed by the area of law in which it actually fits. So the fact that Canada has kind of done this, where we have one regime for copyright, we have one regime for defamation, we may have regimes for other things going forward, I think that that's more sensible and reasonable, and where we're more likely to get good law and policy in each of those areas, rather than trying to pick one solution that applies equally across the board.
Okay. And speaking of defamation, one of the attendees was wondering how your proposal relate like interface with the defamation.
That's an interesting question. I think it wouldn't necessarily, because, so again, defamation is one individual launching a legal action on the basis of defamation. Perhaps, actually, I think the fact that defamation exists already may maybe mean that it doesn't make as much sense to go the route that I'm experimentally proposing, because the defamation action is already available. But I think the difference is that defamation would be one person suing the platform for defamation, and that I think would be caught by intermediate liability. Well, it would be caught by CDA 230. I guess it would depend on the knowledge component in Canada. Because it's one user, it's the person who posted the allegedly defamatory content, and you're trying to hold the platform responsible for that, and that would be difficult. But in this case, it's not about one user being defamed. It's about if you can show that there are so many people being defamed based on a particular protected characteristic across the board on the platform, like it's just happening in droves. And you can show that it's directly related to the elements that I talked about earlier, to the platform's business model and affordances, and that they knew about it and didn't do anything to try and mitigate it, then at that point, I suppose you could maybe, provided all the other factors work, attempt a litigation for systemic defamation, for example. Again, that's very experimental.
Okay. Another question. So someone is wondering where industry standards or best practices fit into all this, and that in the end, like it seems that companies could shield themselves by claiming, for example, that the industry standards for developing a social networking platform are like such, and regardless of what is like reasonably foreseeable by any group, and that like accommodating individual or group concerns, no matter like how foreseeable, go beyond the best practices.
Yeah, so I do envision I definitely envision showing that they've met best practices and due diligence as a form of defense. And one way that they could show what is the standard of care that was met could be by reference to industry standards. But I would just be careful in using industry standards as a reference point in and of itself, because oftentimes they may not actually meet what we feel is needed or is equitable to effectively address the harms in question.
Okay. Another question. So one of the attendees highlights that in tort law, isn't foreseeability bounded and informed by the content of the duty of care? And so could you connect this discussion up to the debate about a duty of care for platforms, like the debate that is still raging about this? And I don't know if you saw that piece, but also like the question referred to a Daphne Keller blog post on systemic duty of care that she published a few days ago.
I have not seen that blog post, although I've read many other things by Daphne Keller, which are all excellent. So I think this is what I meant by when I said I was focusing exclusively on foreseeability, is that there is like that duty of care analysis does have to be done. And there's ways that I could see it being done, for instance, with the proximity element, for example. You could say that because social media platforms and other digital platforms are now our new governors, as Kate Klonick says, that may be enough to establish, for example, a proximity factor where there is a relational component that gives rise to a duty of care. So that's something, though, that I basically pinned for future work, is that it's a question that has to be investigated.
Okay. And then one question. So I don't know if you listened to this, but last week, so Michael Geist had a conversation with Nick Suzor, who is on the Facebook Oversight Board. And one of the challenges discussed was scale, like the impossibility of accounting for global diversity with a user base of like 2.5 billion in the single board. And applied here, how does this proposal scale? Is it based on localized foreseeability or like a global one? So yeah.
great question. Definitely have that episode on my playlist. Should have probably listened to it before this presentation. And it would be a localized standard because I don't think it is possible to apply a global standard. I'm definitely cognizant that scale is something that is easily underestimated as a barrier. But in this case, it would depend on, so going back to the Supreme Court case about the reasonable person, for example, they said the relevant standards, the reasonable person as part of their local community. And I think that's something that could be drawn on to inform this.
Very civil, like other question, let me check.
All the questions, everyone. It's very.
Someone is wondering, so one of the question is, would the obligation for reasonable foreseeability not contradict some like IP protection held by a platform? And also, so, usually like users, they sign contract, like the infamous like standard form contract, well, they absolve like a platform from any tort liability. So how would your proposal like interface with that standard form contract practice of those big platforms?
Okay, so there's two questions here. I'm not sure I completely understand the question about IP held by platform owners. Is this supposed to be distinct from the copyright regimes?
It might be, not sure.
I think, okay, well, I can address that as compared to the current copyright regimes for intermediary liability, which is, I don't think that this, correct me if I'm misunderstanding the question, but I don't think this would contradict, because the way I see it, what I was trying to do was to address the types of harms that don't already have clear legal remedy or avenue of legal recourse. And I think copyright is the least, is the area that least needs that right now with respect to intermediary liability. With respect to the contrast question, that's a really good question. I would point you to the work of Marina Pavlovic, who has written a really great article on how these contracts that we sign don't match the traditional idea of a contract where both parties have equal negotiating power, there's a meeting of the minds. These contracts are non-negotiated, standard form contracts with no bargaining power. And so you could argue it would be an additional legal barrier if that's the case, but you could argue that the contract itself shouldn't apply because of the conditions in which it's signed.
Yes, no, yeah, for that kind of question, I also highly recommend to go read Marina Pavlovic scholarship. And also she has an upcoming piece soon to be published on that question. Another question we have, so because you mentioned it would not be like an individual right, how do you see the implementation of such a proposal? Who would be like in charge of, like actioning it, etc.?
I think so. This is something that would have to be worked out more at the implementation phase. But I think you could see it, for instance, as a potential class action proceeding where you have a representative plaintiff, but they are representative of the entire particular class that's involved.
Okay. Perfect segue to the next question, which was actually like, what would you suggest a specific targeted group do to address this? And for example, a Canadian First Nations, and so that person was asking like class action question mark. So
I don't suggest any specific targeted group has the responsibility or that it's in their particular court to address this. This is more a legal remedy that potentially could be made available to any targeted group that thinks the law applies to the facts of what's happening to them on a particular online platform. I think that the easiest and most straightforward way would be to make reference to pre-existing charter law, pre-existing human rights codes, and look at the type of groups that are already protected under those laws.
Okay, thank you. I'm looking at, so you already answered like some question, although there is one, maybe I would like to go back to section 230. And one of the question, like one person was asking if you wanted to share some more thoughts on how would intermediary liability likely like evolve once, I'm quoting, Trump butchers CDA 230. Although, like, is the EU actually doing anything?
That's why I've been hesitant to invest too much time in it, because I'm not convinced it's actually going to amount to anything yet.
It does not.
No, so much is in the air. So until another government body responds, or the FCC starts the rulemaking process, or it hits the court, then I'm not.
They even have that power. It's like to be determined.
Yeah.
Okay, looking. I have one question myself, something. So at some point, you kind of did like a side note about like with a call to developers, about like location based APIs and stuff. And you're like, please discuss with experts about like gender-based violence and stuff before like implementing such tool. So yeah, it's not really like related to your talk, but because you mentioned this, I would love to maybe like hear you about this and why you wanted to. Well, I kind of know why, but for the benefit of everybody, I would love to hear you about this.
Sure. And basically, it's just because we see repeatedly that products and services will be rolled out with this feature, immediately have harmful consequences for women and for others who are stalked and tracked through these location apps, and then release a statement afterwards saying that they didn't foresee this harm, or they didn't see this harm would happen. And there's three specific examples that I can think of. The first one is Snapchat rolled out, I think it was called the Snap Map feature, where it would pinpoint your location to all of your contacts on your Snapchat list. And not only that, but it would by default send out your location to everyone on your contact list whenever you even opened the app. And it was possible to turn off this feature, but they did not necessarily make that clear. And once women's rights advocates and gender violence support workers started raising these concerns, Snapchat addressed it. But my question, as it usually is with these things, is why didn't they know or see or were told of that beforehand? Similarly, there's a private email service called Superhuman, and they were known as a really popular, excellent paid email service. And they rolled out a feature that included read receipts, so you could see if someone opened your email, but you would also be able to see where they were when they opened your email. And that was something that provoked a lot of outcry after it came out. And to their credit, the team at Superhuman completely took it in stride. They acknowledged what happened. They understood what the concerns were. But what struck me was they said that I don't remember the exact sentence, but it was words to the effect of this possibility hadn't occurred to them, that someone would use location tracking as a means to engage in abusive behavior. When people who work in the field of intimate partner violence, for example, or tech-facilitated gender-based violence, this is the first thing they would have thought of. And the third example I would give is, I guess the reason that was front of mind is, I guess to plug other work, is last year at the Citizen Lab, I co-authored a report on the use of stalkerware apps, which are apps that people install on their partners or ex-partners' phones to spy on them and monitor their online behavior covertly. We did a Canadian legal and policy analysis of that. And so this is, to my mind, one of the most, it's a good example of something that is just completely obvious and predictable that you would think of right off the bat for those who have experienced it or who are paying attention, but yet is completely unconceivable to the person who's actually creating these types of apps and platforms.
Okay, thank you so much. There is, and kind of ongoing conversation about scalability in the conversation. I will invite you to to go read it after the, after the talk. It's great. Anyway, so thank you so much, Cynthia, for joining us today and for your proposal and for the conversation. Thank you, everybody else, for joining us for this virtual talk. And about, like location-based apps, API tools, and contact tracing. If you're interested in this, I would invite you to join us next week for the next virtual talk. We will welcome Polly Sanderson and Teresa Scassa for a conversation with Lauren Reed about privacy challenges with COVID-19 contact tracing apps. I just published in the chat the link to the webpage for next week event, and so I will invite you to RSVP to this event. Until then, I wish everybody a lovely end of the week and see you next week. Thank you, and thank you again, Cynthia, for joining us today.
Thank you so much, everyone.
Bye.